The broadcast is now starting. All attendees are in listen-only mode.
Good morning, this is Roger Royse, founder of the Royse Law Firm, a business, corporate, and tax firm with offices in Northern and Southern California. I'd like to welcome you today to our webinar, Top 10 Mistakes That Startups Make. This webinar features Lisa Chapman, Fred Greguras, and Chris Chillingworth, who are going to describe some of the top legal and financial mistakes that they've seen in the startup world. A few housekeeping items. I'd like to let you know that this webinar is being recorded, and you'll be able to listen to it at your convenience later by finding it on our site, royseuniversity.com. It'll also be available on YouTube, available as a podcast in the Apple's bookstore, and the materials will be posted on SlideShare as well as on Royse University. Throughout the webcast, if you have questions, you'll notice in the right-hand corner of your screen a dialog box. You can type your questions in, and we'll take them at the end of the program. So before we start, I would like to mention that we do have several other events coming up. On October 1, we have a luncheon event that's not a webinar. It's actually going to be a real live in-person luncheon event on M&A transactions that Fred Greguras will be involved in. Please email us for details about that. On October 15th is our next webinar. We'll have with us John Kabeka from the USPTO here on the West Coast, and the presentation and panel will be on the use of patents in startups. We have a series of webinars. We've taken the summer off, but now we're back. We've got a series of webinars coming up this fall and this winter, including webinars on trade secret theft, privacy law, and our tech series will start off with a presentation on the sharing economy. So for today's program, the top 10 mistakes startups make, we have, first of all, Lisa Chapman. She's an attorney with Royse Law Firm. She represents startup and mid-sized companies and has for over 20 years in the areas of employment counseling, employment litigation, commercial litigation, and trade secret litigation. Her practice includes a concentration on wage and hour laws, employment policies, hiring policies, training, leave of absence, and other employment-related issues. She practices in many courts, federal and state courts, the EEOC, the U.S. Department of Labor, and the California Department of Labor. We also have with us Fred Greguras. He is an experienced business lawyer and entrepreneur. He's certainly a Silicon Valley veteran that most of you have probably run across at one time or another. He works with global and U.S. businesses ranging from startup to public company, although his emphasis is on startup and emerging growth companies. A big part of Fred's practice includes foreign companies expanding their operations into the United States, including clean tech, semiconductor, medical device, and software. He does equity and debt financings. He advises on M&A, joint ventures, licensing and business transaction, domestic and internationally. And finally, Chris Chillingworth is a partner at CFO To Go. He's been in the financial business for 40 years now. You wouldn't know it to look at him. In fact, he's had it so long, when he started, it was Ernst & Ernst instead of Ernst & Young. He's a CPA, or licensed CPA, inactive now, has been an entrepreneur in real estate, and his career is devoted now to high-tech business. He's a public company CFO, or has been, and a vice president of finance, and leads CFO To Go's financial systems, technical accounting, and enterprise risk management practices. So with that, I would like to start things off by turning it over to Lisa.
Actually, we're going to start with Chris.
Chris, okay, for Chris.
Good morning, everyone. We're going to talk today on a number of different topics, some of which will seem, kind of self-explanatory and whatever, but I still encounter them after 40 years in the practice with all my small and medium-sized enterprise companies. As we all know, Southwest Airlines was founded on a napkin, but that's not really a plan. So financial mistake number one I find most often is that a lot of the startups start without a plan. They have a plan in the sense that there are buckets of dollars that are going to be spent on marketing, advertising, sales, whatever, but that's not really a plan. And without a plan, you know, the spending is then driven by liquidity, not with goals. You know, when the money comes in the door, the tendency is to spend the money on things that there's some pent-up demand amongst the engineers in the organization, new computers, new servers, that sort of thing. And, you know, things like staging are largely ignored. So they treat the money as though all the revenue is going to come in on the first day, which it isn't, and that the ability to group the purchases together to get quantity discounts and stuff is largely ignored. From my standpoint, the planning process itself is more important than the actual result. So the piece of paper that is created or the report that comes out of the planning process oftentimes is obsolete the day it's written, but the process itself, the process of allocating resources, identifying what the goals are, assigning accountability to the various goals that are being you know, attained in the company is the most important process there is, much more important than the result. To quote a colleague friend of mine, the company should be run with a checkbook mentality, meaning that the CEO, not necessarily the CFO, should know how much is in the bank at any time. We counsel our clients to build a 13-week forward-looking cash forecast that's updated weekly, so that at all times the company knows what's coming in and what's going out for the next 13 weeks. It's very troublesome to determine on Wednesday that you don't have the money in the bank to make payroll on Friday. Always consider contingencies, always have a plan B. What I like to say on slide number 3, I guess, is that what constitutes a real plan? First of all, the plan ought to have accountable units. So it shouldn't just be marketing $300,000. It should be, we're going to spend this much on advertising, we're going to spend $10,000 building a website, the website's going to have these goals. We're not going to hire just 5 people, but we're going to hire a VP of engineering, we're going to hire a software engineer, we're going to do it in this time frame. So every cost in the plan has to have accountable units, hours, quantities, prices, headcount, and a specific time frame for each cost, a specific goal or milestone to be achieved by the expenditure. And this is really important because it's not just spending a bucket of money, but it's spending a bucket of money to achieve a goal. And finally, one of my favorites is a belly button to push, accountability for the specific goal and the specific expenditure. The worst thing that can happen is that you can't explain variances to the board other than to say the plan, we didn't budget properly. Only by the use of accountable units, a specific time frame, and a goal can you determine why your plan isn't operating according to your goals. And with that, I'll turn it over to Lisa.
Thank you, Chris. On slide 4 is it's entitled Legal Mistake Number 1, Failing to Legally Document Your Company's Status with Founders, Employers, Employees, and Third Parties. It seems very self-evident that you should do this, or all companies should do this, but I actually believe this is the most common mistake that I see in working with startups and mid-sized companies. And probably you're asking yourself why, and I think it's because there's a certain amount of trust that's inherent between folks that get together and under pretty tough circumstances try and find or create a new business out of nothing. At that point, they share the same goals and have the same interests, but as time passes, problems arise, certain people prove not to be as valuable as others, certain people want to take their life in a different direction and perhaps want more stability. It turns out that all of the reasons why you trusted your co-founders don't always exist a year or 2 or 3, 4 years down the road. So what companies need to do is to document their business activities at the very beginning. This is not an expensive process, by the way, but it is, I consider to be probably one of the most important mandatory requirements. So why should they do it? Obviously, I've given you a little taste of it, but probably the most important reason is so that the founders can avoid personal liability. And so personal liability is going to attach to the founders if they don't create some sort of a buffer or barrier between them and the folks that are going to interact with the company. And if you don't create a corporation or some other recognized business entity, a partnership, etc., you, the founders, are potentially personally liable for every debt you don't pay to an individual, a corporation, or the government. Second important reason to document your business activities, especially at the beginning, is to create a written record of the decisions of the company and the relationship between the founders and board of directors. Without documentation of what the decisions are, various shareholders or third parties can make challenges to the company, and if the company doesn't have a proper written record of its decisions, it's not going to have very good evidence to refute a lawsuit or to push back on someone who is making a claim which is contrary to what the board or the founders feel is appropriate. And the third, quite similar on that same vein, is to document all of the decisions or actions between the company and third parties. Again, this seems very self-evident that every contract would be written down, there would be a proper record, but that's just not the case. And as someone who tries cases involving commercial disputes and disputes involving companies and employees, I find that there is a dearth of proper written documentation to this day, and that most of the evidence which companies need to defend themselves against challenges is going to be living in emails, and as you probably know, that's just not as sound a source of evidence for a defense, to mount a defense, as if you had a simple contract which spelled out the rights between all the parties. Sort of related to this is when should you do all of these things? And my sense, and I think probably everyone in this room, is that as soon as there is a potential risk, as soon as there is an action which creates a potential risk of liability or for which regulatory or statutory compliance is required under federal, state, or local law, you need to start documenting your actions and make sure your corporate status is properly recorded. So this would include any time you are involved in quote-unquote commerce. That's what the courts are going to look to. Are you involved in the sale of products or services? Are you hiring folks to provide products and services? Do you have interns? Do you have employees, independent contractors? Have you entered into a lease for your business offices? Are you paying taxes? Any of those actions mandate that the company's status be properly documented. And when I say status, I don't mean just the documentation between you and the government, in other words, forming a corporation, but I also mean documenting the relationships between the founders, as I mentioned earlier, to make sure that there's no loose ends and everyone's on the same page. Finally, you may be wondering, even though it seems obvious, but it's not actually, how is it that taking these steps protect a company's founder from personal liability? And the answer is that as long as you, a founder or a company or representative of a company, do not commit acts of fraud against other individuals or third parties or the government, the corporate entity will protect you and shield you from personal liability. There are some exceptions having to do with tax compliance, et cetera, but that is the general theme that I feel comfortable if you act within the scope of that. One other exception is if the shareholders breach duties, or sorry, the board of directors or representatives of the company breaches duties owed to other shareholders, in which case there may not be that shield of personal liability. Now, I would also, just as a final thought, add that I always recommend to our clients to hedge this issue and take even greater precaution by getting properly insured as soon as you possibly can to make sure that you've got a second line of defense or protection in the event of unwanted litigation. Chris?
Thanks, Lisa. My financial mistake number 2 is probably less relevant to the experienced serial entrepreneurs that have done this many times. But here in the Silicon Valley, we have a lot of startups that are started by basically kids out of college who have had an idea, maybe couldn't find employment immediately, so they're running with their idea as a means of establishing themselves and generating some income. But what I find is that treating the company as their own personal piggyback is definitely the wrong way to go. And it's very easy when they're living in an apartment with 4 engineers and cables all over the place and servers and whatever to bring in every meal. Everything is treated as a business expense, car, travel, whatever. I recommend that the business and the personal aspects of an individual be kept entirely separate. So use separate bank accounts, use separate credit cards, file expense reports for business activities. Business entertainment expenses under the IRS code have to be documented. All the essential elements of who, what, when, where, and why you entertain this person have to be documented. So keep personal expenses out of the business and run your business as a business. The IRS identifies an aspect of certain fixed assets as listed property, meaning it's property such as cell phones, automobiles, computers that can be used both for personal and for business purposes. And oftentimes the two are commingled. And in such a case, the regulations require that you keep logs or some evidence of your personal use versus your business use of these items and deduct only the business use within the company. As Lisa mentioned, all your business activities should be documented. Your board and management actions be documented in minutes. One of the things I found is that oftentimes you'll get an angel investment or whatever that is where the investor is less than 50% of the ownership of the company, therefore is a minority investor. And yet the founders, who are not only board members but officers of the company, tend to treat the actions of the company as though they were owned. We're on the board, we control the board, we're not accountable to anybody. And the truth of the matter is, if you spend the investor's money frivolously, you'll find out through an investor's lawsuit that maybe the minority investors did have some rights after all and make your life miserable. So again, run the business as a business. Lisa mentioned that one of the first actions a lawsuit will take will try to pierce the corporate veil and attempt to attach personal liability to your actions as a business. So again, document everything, separate your personal from business expenses, and treat your minority investors as a fiduciary would. Lisa?
Legal mistake number 2 is ignoring obligations under intellectual property and trade secret laws. What is a trade secret? A trade secret is information that is not generally known to the public that has economic value and is treated as confidential by the holder of the secrets. This includes technical and non-technical information, such as customer lists, know-how, and business plans. So a couple of key points here. So this needs to be something that you derive value from, and that's how a customer list gets on this, falls into this definition, because information about your customers' pricing, preferences, order, shipment requirements, etc., is information which your competitors could use to their benefit if they had access to that information. Another key point is you, as the holder of a trade secret, have to keep confidential this information. You cannot and must not ever post your trade secret on your website. That is the best way to destroy the trade secret value or the value of your trade secrets. I highly recommend against posting tombstones on your website which brag about who your customers are, etc., because it'll be pretty tough later on in a lawsuit to argue that you kept your customer list confidential if you've been boasting about it to everyone who has access to your website. What is intellectual property? You probably all know this. It's generally the category of trademarks, patents, and copyrighted materials. I'm not going to go into detail about what the elements are of each of those categories, but suffice to say, those are the other types of intellectual property that you need to protect. And when I say ignoring obligations under IP or intellectual property and trade secret laws, I mean failing to properly follow the legal requirements to preserve the integrity of these rights. So depending on which type of intellectual property is at issue, you need to file certain governmental, make certain filings with the government, with the exception, of course, of a trade secret, which what you mostly need to do is keep it secret and only give information about your trade secrets to those that need to know it. So when you're forming a company, or you've already formed your company and it's in a nascent stage, there are important considerations you need to take into account. At that point, you really are focusing on your defensive strategy. And by this I mean you need to think about what are the pre-existing obligations your team may have to former employers. And I say this because at that point, a company is vulnerable to being sued or alleged to have violated the trade secret rights or intellectual property rights of employees, former employers. So ask all your recruits and your employees to let you know what non-disclosure agreements or NDAs they have, or covenants not to compete that they've entered into in the context of a merger or acquisition with respect to a former employer. You need to know what those are, because you need to make sure you do not encourage or allow any of your employees to violate intellectual property rights of a former employer. Very, very important obligation. I say defensive because if you don't do this, you could draw a lawsuit, and it's very likely it could put you out of business. It's a very common strategy for companies to essentially challenge companies formed by their former employees on this ground. And it's a very expensive lawsuit to defend, which is why, unfortunately, a lot of startups can't survive this stage. So the flip of this is what are the obligations you need to think about when your company is up and running and in a more mature stage. At this point, you have the ability to adopt a more offensive strategy. And by this, I mean the company should aggressively protect its property and be mindful of potential breaches of intellectual property rights. Of course, this includes breaches by former employees who've gone on to form their own company. So at this point, when someone important to the company who has access to intellectual property that's important, or even just trade secrets, goes to another company or forms another company that's going to compete with your company, you need to make sure they receive a letter from your attorney telling them that you're watching them and admonishing them not to violate your company's intellectual property rights. Chris?
Thanks, Lisa. Financial mistake number 3 is the failure to develop a meaningful accounting system. Let's face it, accounting systems these days are dirt cheap, whether you have an on-premise solution or your solution's in the cloud. This simply isn't an excuse any longer to maintain the books and records of the company on spreadsheets or in checkbooks. Develop a system that is meaningful, that provides you meaningful data on a daily basis, basically. Don't just treat the system as simply a repository for receipts until tax time. A meaningful accounting system means that the accounts are structured to provide meaningful data, so don't just use the plain vanilla chart of accounts that comes out of the box with QuickBooks or whatever. The accounts are listed alphabetically. They should be grouped in meaningful buckets so that, for instance, all the employee costs are lumped together. So payroll taxes, workers' compensation insurance, health insurance, all those are an employee cost and should be grouped together so that you can find out what your total investment in your employment population is. Similarly, facility costs should be grouped together. So rent, property taxes, utilities, janitorial, whatever you pay on your facilities should be grouped into a single category. Not to say that you don't have the detail underneath it, but group your accounts into meaningful buckets so that then you can trace your progress towards your goals and be able to manage those expenses against your budgets and your targets. Pre-authorize your expenses. I'm totally against giving a credit card to every employee. Why? Because the expenses, once incurred, are very difficult to undo. Once the money's spent, it's spent. But if every employee is required to get pre-authorization before they spend something, or if they spend it on their own and then come for reimbursement and it's not part of the company's plan, you can deny the expenditure. So the company ought to have some methodology, whether it's purchase orders, purchase requisitions, some means of pre-authorizing expenses so that they're not caught later. And the corollary to that is make sure that the transactions of the company are entered timely. I can't tell you how many situations I've been in where the expense reports of the sales VP come in months later, long after the expense has been incurred, and there are items on the expense report that are just outlandish, and now that they've been incurred, we have to pay them, but they weren't part of any planning process. So make sure that you have a process by which transactions are entered timely. There are all sorts of software packages out now where you can capture data. I'm thinking of Expensify, a company called Concur. There are others where you can literally scan your receipt as you're paying and have it uploaded immediately into your financial system. I highly recommend those solutions. They're very cheap, very inexpensive, and very, very meaningful in terms of having timely financial data. Lisa?
Legal mistake number 3, don't ignore employment laws and regulations. My client, who I've just spent the last 2 mornings with at the Labor Commission, could attest to that. Failure to comply with employment laws and regulations is something that can bring a company down probably quicker than anything I've seen in a long time. Companies are heavily regulated. Employment laws are enforced vigorously. Companies cannot fly under the radar, even though they think they can and should, even though They tell employees, work for free, I'll pay you later. If you don't pay later, you're going to probably end up with the Labor Commission. And you're going to get a judgment within 30 days of finding that you owe the money, and if you can't pay the money, it's going to really affect your ability to get an exit for your company when you've got judgments levied against the company for failure to pay wages. So what is the scope of risk in the event of noncompliance? It includes litigation costs, loss of morale, investors' concerns, and impact on the final exit, as I mentioned. And the biggest source of concern right now that I see companies need to focus on is two issues. One, complying with wage and hour laws, that's paying employees what you're legally obligated to do, how you're legally obligated to pay them in terms of amounts, times, dates, etc., and overtime. And second, it's the issue of the determination of the status of your workers, that is, whether or not they are an independent contractor or employee. Those are the two biggest issues you need to focus on. Question I get all the time, can I use forms that were created by some other company to document my employee relationships? The answer is no. You need to have your forms, your documents rather tailored to your company, and oftentimes people use forms that are outdated and include information and make assertions which are not enforceable. So why can't you treat your workers as an independent contractor as a means of complying with employment laws and regulations, including the payment of payroll taxes? This is a question I get all the time. Gee, can't I just have my independent contractors form their own company and pay them through that company, and that way I don't have to pay payroll taxes. They'll get a 1099, they'll be happy. The answer is because sooner or later a governmental agency is going to nail you on that. And in our experience, governmental agencies, taxing authorities, U.S. Department of Labor, sometimes Department of Immigration, state departments of labor, labor commissions, are very aggressively seeking to monitor this issue. And you can even see it on the U.S. Department of Labor website. And it's obvious why, because this is how they collect money. So anything you do to get in the way of the government collecting money is going to bring you to a situation where you're being scrutinized. And briefly on that issue of what is an employee versus an independent contractor, do understand that's a sophisticated subjective determination that needs to be made on a case-by-case basis. It should be made by a professional. Liabilities attached, criminal penalties attached to an improper determination. So it's not a good idea to just pretend that everyone's a contractor, because you can call them a contractor. You can have a document that's called independent contractor agreement, and that is not going to turn someone who's an employee into an independent contractor. Just a quick note, pay special attention to how you treat your interns as well. There's a myriad of laws and regulations which separately address the issue of determination of status of interns and how you have to treat them and pay them or not pay them. Finally, without going into the details of these areas of subsets, rather, of employment law, do know that there are a myriad of other laws and regulations under the rubric of employment law that need to be considered, and this includes sexual harassment, discrimination, and somewhat related immigration laws. Do not think that the days of sexual harassment and discrimination are over, and in fact, a lot of people have noted what appears to be an increased volume of age discrimination happening at this time. So there are a lot of concerns that you need to have, and you need to follow these laws and regulations. Chris?
Financial mistake number 4 is the failure to pay taxes. Most of this occurs because the young entrepreneur doesn't know the gamut of taxes that he is subjected to. There are federal and state and local income taxes, federal and state employment or payroll taxes, real and personal property taxes, sales taxes, use taxes, local taxes, foreign taxes, specialty taxes. My recommendation is that you have a professional develop a tax calendar of all the taxes that your company is subjected to, how those taxes are, because in most cases they're self-assessed. Do you have the systems in place to calculate the taxes, because they'll be subject to audit? Use a payroll service that collects, remits, and report taxes to you. There are a lot of software packages out there that calculate the taxes, but if the taxes are not collected at the time that the payroll is paid, then they tend to be ignored until the quarterly tax return is due. And oftentimes, if your financial system is just punching out the calculations but not completing the returns for you, you'd wind up either being late or not paying your quarterly payroll taxes at all. So generally speaking, the payroll services are extremely economical. They take care of all the filing requirements for you, and they collect and pay the taxes as and when they are due. Understand particularly what trust fund liabilities are. Trust fund liabilities are the liabilities that arise when you are to withhold taxes from an employee's paycheck, for instance. Those taxes, the failure to pay and remit those taxes, can be a criminal liability, not just a civil liability. So make sure that your trust fund liabilities in particular are paid on time. And then realize that substantial penalties and risk of business forfeiture can result from the non-payment of taxes. IRS is the most efficient tax collection mechanism on the planet and can shut your business down. I mean, I have an example of a client of mine, no longer in business, that was paying $5,000 a month against a $60,000 IRS liability, tax liability, and the IRS came and shut them down anyway. Go figure. So that doesn't mean they have to act rationally, they just act. You know, in some substance, treat your taxes as a priority, pay them on time, and don't ignore them.
Legal mistake number 4, failing to document your legal relationships with third parties. I have covered this somewhat, so I'm going to sort of speed through this to give you more time for questions. The risk, as I've identified it, is avoiding misunderstandings that can lead to costly litigation. And so, essentially, you need to have everything in writing. Handshakes, oral agreements are just not enforceable. And in fact, I mentioned I was at the Labor Commission this morning and yesterday. That was a big issue at the Labor Commission hearings because there weren't contracts. And that just creates problems. Really hard to defend yourself if it's a he said, she said situation and the other side saying the opposite. You just don't have any protection if you go that route. So put everything in writing, proper contract, and make sure it includes all of the things it needs to include, and contracts should be written by professionals. So this includes also contracts with all of your customers and any third parties, and make sure you use forms and documents that are tailored to your company. On that same vein, maintain a thorough record of all of your contracts, and also back up all of your documents electronically. Make sure you've got good digital protection that's going to help you in the advent of any potential litigation, and also in case a governmental agency comes after your company for some sort of violation, such as the failure to pay taxes, as Chris just explained to us. Chris?
So the last of my major financial mistakes is the failure to keep some of your powder dry. This is kind of a corollary to my Plan B in the planning segment, but a lot of times companies feel pressure from the investor or the VC to put the money to work immediately. and they misinterpret that as spend it all. And without maintaining reserves for unforeseen contingencies and delayed timing, you know, you're asking for trouble. You're asking, you know, to basically forfeit your business. Understand the difference between a VC investor and an angel investor. A VC investor is a professional. They do this for a living. The VC investor tends to lead the company to believe that in a journey from the West Coast to the East Coast, there'll be a filling station in Denver and a filling station in Chicago. That's not necessarily true with the angel investors. And while there are notable exceptions, most of the angel investors are a little bit less sophisticated than the VCs. The first check you receive from an angel investor is likely to be the last. So it's very important that you manage those investments properly and that you stretch them as far as you can go. And in that respect, use a financial professional to stretch your capital. There are all sorts of ways of doing that. Equipment leasing for your fixed asset purchases. Standby letters of credit to secure your security deposits for your real estate investments. Asset-based lending for receivables and inventory and fixed asset lending. So in addition to the capital you get as equity, there are all sorts of ways of borrowing to stretch the capital even further. Lisa?
Final legal mistake I've chosen to talk about is corporate governance, i.e. failing to comply with laws and regulations which deal with corporate governance requirements. The risk here is that by failing to document what you do and act as a board properly, there can be confusion between board members and shareholders about the goals and duties and what's been done and what hasn't been done. And that can lead to litigation. So take the time to write minutes or have someone write minutes for you after you make your decisions, because if you go back at the end, say you're doing an exit and you're trying to move your company forward to the next stage, and you haven't documented what's been done, you will find yourself in a situation where you'll have to scramble and clean up your corporate records, and problems can be uncovered at that point and become time-consuming and expensive to cure. Whereas if you just took the time when decisions were being made to properly document those decisions, you could avoid problems in the future. I think that your funders would appreciate it, and I think you stand to be in a much better position to receive funds from outside sources if you are treating your company like a true company and not as a pet project. So you need to invoke and follow strict rules for corporate governance. You need to hold necessary board meetings, board of directors meetings. You need to document decisions of the board with minutes. And you need to follow statutory obligations which govern or deal with corporate governance, such as notice requirements for meetings. Finally, a key issue here is you should not act informally when formality is required by the law. You need to work with an attorney to make sure you are complying with the formal requirements which the law imposes.
Shall we throw it over to Q&A?
Yeah, throw it open for questions. Okay.
So do folks have any questions for us?
So in the right-hand corner of your screen, you'll notice a dialog box. Go ahead and type in your questions if you have any questions for our panelists. I guess while we're waiting, let me start things off. There was an article in one of the major publications, I forget which one, the other day, talking about this new, I guess we'd call 1099 economy we have out here in Silicon Valley, and we've always sort of had that, but it's just gotten a lot worse lately, it seems, because it's so easy now with the sharing, the peer-to-peer sort of applications out there that's so easy to outsource and do work remotely that you find a lot of companies that that are so virtual they don't even have employees. They have all 1099 or all independent contractors working for them. And I wonder if our panelists might comment on the sorts of issues that's raising these days, and whether if there's any hidden traps to watch out for in that. And Lisa, why don't we start with you, because I think this is more up your alley.
Yeah, this is a really profound problem right now, and I get a lot of pushback from clients who, you know, just, well, let me just make this person an independent contractor. You know, they don't want to be an employee. They want the tax advantages of a 1099. And all I can say to these folks is just wait till you get caught, because it's really an incredibly expensive proposition to defend yourself against both the taxing authorities and or an individual who becomes someone you treated as an independent contractor later claims, oh, I should have been paid as an employee, and then brings a claim in the Labor Commission or in Superior Court. And do let me tell you, that would be a wage and hour claim. And more importantly, probably the most important fact that impacts economic impact of this on a company is that wage and hour laws, most of them, some of them the ones that unfortunately you encounter in the situation of non-payment of full wages, carry with them an attorney's fees clause, which means that you are going to have to settle for a lot more money than you probably owe that employee. And it's going to be expensive. It's just not a good risk at this point. The taxing authorities are aggressive. I'm seeing more and more situations where folks are filing for unemployment after acting as independent and treated as independent contractors, and that is invoking investigations by unemployment boards all across the country. We have this in multiple states, our clients in multiple states coming to us saying, there's an investigation about how we treat our employees. Gee, what do we do now? And now they have to go back and resort through all of these relationships. And once there's one lawsuit or one claim, it's you know, the floodgates are open. So it's a really serious and ugly risk.
One of the issues on intellectual property that you see in independent contractor agreements, not only with startups but with big companies, is when the contractor is transferring the rights of ownership to the company. And you see language in there that says work made for hire. If you are in California and you have that work made for hire language in there as part of the transfer of the property, then that's going to make those contractors employees for certain purposes of California tax law. That's a pitfall I see all the time.
In addition, there are more than 20 factors the IRS uses to classify whether you're an employee or a independent contractor. And the important thing to know there is that it's not an absolute. It's a judgmental factor. You know, there are more of the factors, in fact, you know, driving you towards an employment relationship as opposed to independent contractor relationship. And note that the penalties for failure to properly classify include the payment of both employment and employee and employer taxes to the federal government for misclassification of employees. Finally, there's because of the Affordable Care Act, there's a lot of pressure on companies to keep their employment bases down below the limits in which they have to undertake that obligation. So there's that pressure out there as well.
By the way, for those of you who are tweeting, you can use hashtag startup. You can follow us on Twitter at @RRoyceLaw and at RRRoyce00. Another question that's come in, and this is probably more for Chris, that goes back to your first slide. I think somebody is asking for some clarity about how to view liquidity and cash management, because you say decision making is driven by liquidity, not goals, without a plan, but later on you say you should run the company with a checkbook mentality. Can you explain a little bit more about what you mean?
Sure. What I meant by the first bullet point was that without a plan, all you have to judgment by is what you have in the bank and oftentimes $1 million comes in as an investment, and there's this rush to spend the money without really arguing the plan and the goals and that sort of thing. But it's also important for the officers, particularly the CEO, the CFO, to know what's in the bank and to run their company, knowing what's always there and what's left. And so there's a whole forecasting process that we recommend that helps also guide the liquidity aspects of the company and what the immediate objectives are.
Take it.
Yeah, the next question is, how would one deal with 1099 with a foreign person working here in the U.S. or possibly working for a U.S. company, but in that person's home country? Well, if someone is typically your status as an employee is determined by the country you're living in. So if you're living and working in, say, for instance, India, you're governed by India employment laws and regulations. If you're here in the U.S., your employment is governed, or independent contractor status is governed by the state in which you are providing services. So to the best of my knowledge, we are not obligated to tax foreign workers on any level, employment or independent contractor status. Roger, do you have any
Unless they're working here in the U.S.
Yes, unless they're providing services in the United States.
Yeah, that's generally true. Okay, so let me ask.
Here's one more question.
Oh, we have another question's come in.
Payroll is one thing, but what outside service provider would you recommend to handle hands-on employee onboarding? That is certainly something that we provide assistance to our clients with, and sometimes we work with other professionals, but we generally start that process and then work with others as needed.
Yeah. So, at the time we've got left, I wonder if I might ask our panelists if they could just tell us what is sort of the number one takeaway that you think people should have here today. What's the number one thing they should watch out for? If your audience could remember one thing out of this webinar, what would you like them to know? And we'll start with whoever wants to start.
Well, I'll take that. I mean, I think the most important thing is that the law is your friend and your foe. If you follow it, it actually helps you, and you get protection from the law. But if you ignore the legal requirements, corporate governance, employment, you name it, tax, it actually is probably the biggest mistake you can make.
And for my contribution, I would say planning and the systems in place to track how you're doing against your plan are the most important things. Planning is absolutely essential. Companies often get a large amount of money at one time, and the tendency is to want to go out and spend it without really articulating what the goals and objectives of the company are.
Yeah, my takeaway would be finish the paperwork. I see so many startups that get incorporated with LegalZoom or some other way, and there's no other paperwork. And even sometimes when I do the paperwork, it's hard to get clients to complete the paperwork. But you really have to complete the paperwork to get the formalities done so that you have the insulation from liability and some of the other things that we've been discussing today.
I would just make one further point. There are some questions coming in about various services, legal services or accounting services, and you can shoot your emails to us directly and we can respond to those.
Yeah, we can respond to a lot of this offline. We do handle equity agreements for those who are asking, and we can certainly talk to you about some of the other financial issues. I also want to point out that with respect to the paperwork, you'll find that there are very reasonably cost solutions now, including the Royse Law Incorporator that you'll find online for doing some of the very basic stuff, as well as our Legal Wizard. Do we have any other questions here? We've got a few more minutes left if anybody else wants to submit a question. I want to remind you that this webinar is then recorded. You can listen to it again. You can find the materials along with the audio and visual at royseuniversity.com. The slides will be on SlideShare. This will be on our Royse Law YouTube site, as well as available as a podcast for download in the iTunes Store. Coming up, as I mentioned, we have on October 1st next week a luncheon event at Ming's Restaurant on preparing the company for a successful exit. That's a ticketed event, so please email us if you'd like to attend. Our next webinar, October 15, the role of patents in a startup's life. In November, a patent webinar, the date is not fixed yet, on trade secret theft. And we will have a series coming up, our technology series on privacy concerns, sharing economy, and other issues. With that, do we have any final words that you'd like to impart? All right. So with that, I'm going to go ahead and close the webinar. For those of you whose questions we didn't get to, we'll go ahead and respond to you by email. Thank you for attending.